Appeals court upholds law cutting Medicaid funds to Planned Parenthood affiliates.
A federal appeals court rejected Planned Parenthood's challenge to a Trump-backed law that bars Medicaid funding for nonprofits that provide abortions while receiving significant federal support. The First Circuit overturned a lower court injunction, finding the measure is not punishment, but a policy choice under Congress's spending power. Several clinics have already closed since the law took effect.
The law appears in a broader package and uses a funding threshold to block Medicaid dollars from flowing to entities tied to abortion services. The lower court had labeled it a possible bill of attainder, which the appeals panel rejected.
Planned Parenthood argues the rule targets their organization and undercuts access to cancer screenings, contraception, and STI testing for low-income patients. The panel said providers have a choice about services and can separate activities if they wish to keep Medicaid streams. A separate injunction remains in place in many blue states, but today's ruling adds legal momentum for the policy and could shape outcomes in other circuits.
What is the legal nub? Congress can attach conditions to federal funds. The key is whether a statute crosses the line into punishment of a named group. The panel said this one did not.
Clinics that lose Medicaid funds often scale back hours or close satellite sites. Patients may face longer travel or wait times for non-abortion services funded by Medicaid. States with separate injunctions maintain current access until appeals resolve. Whether Planned Parenthood seeks in-bank review or goes to the Supreme Court, and how governors and Medicaid agencies respond in states where the injunction no longer shields providers. Today's decision tightens funding for certain providers in many jurisdictions and sets up a bigger legal fight over how far Congress can go in conditioning Medicaid dollars.